Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Conquer Mains, an initiative for those appearing in Mains 2024. This program is running on the Unacademy app. Then what am I doing here on YouTube? Since this program is tailor-made for those attempting Mains 2024, we would be teaching advanced level. We would be focusing on answer writing. So to give you an idea, what should you expect from this program? That is why we are having this session live on YouTube. From tomorrow, it will be exclusively available on the Unacademy app. And should you wish to enroll in this program, the course fee is $999. You can get access to this Mains 2024 program by paying the course fee of $999. Clear? At the end of this session, I will be sharing notes which would help you write better answers in Mains 2024. Should you wish to get these notes, I will be sharing them on my Telegram channel. The link to my channel is provided in the video description. So please subscribe to my channel and I will share the notes after the session. This program can also be viewed by those who will be appearing in Mains next year. But please understand, I will be assuming a lot of stuff. I would assume that you know a lot of things. So I will focus only on the advanced level so that it is going to help you in your Mains examination. And if you're liking this initiative, also, don't forget to press the like button and subscribe to our channel if you haven't yet. In today's session, we will be focusing on judiciary. And what are the themes I have picked from Indian judiciary? Independence of judiciary. What do we mean by independence of judiciary? And how can we link it with the judicial appointments? Because it has been in the news throughout the year. How do we solve the pendency of the cases? What is the action plan to reduce government litigation? Because government is the biggest litigant, which files the highest number of cases and against whom the large number of cases also have been filed. So from Mains perspective, how do we reduce the government litigation? That can be an important question for your Mains examination. Similarly, this topic was also in the news. Setting up of regional benches of the Supreme Court. What are the arguments in favor? What are the arguments against? Often controversial, judiciary and holidays. The judges take so many holidays, that is why perhaps the pendency of the cases is high. Whether that is true or not, that aspect also we are going to cover in theme number 6. Then we will look at what is a curative petition, because this was in the news with respect to Delhi Metro Rail Corporation. It was also in the news because of the Union Carbide case. Then some of the important judicial judgments, and we will also focus on the doctrine of essentiality, also known as the essential religious practices test, propounded by the Supreme Court in the Shurur Mutt case of 1954. So let's get started and look at topic number 1, theme number 1, independence of judiciary. Now, what do we mean by independence of judiciary? You would know one aspect of it, that judiciary as an institution should be insulated from two other organs of the state, which is the executive and the legislature. So insulating judiciary from the other organs of the state, executive and legislature, that's what we call independence of judiciary. But that's not the only thing. And now listen to me carefully. Independence of judiciary also means that judges, when they perform their task, when they perform their roles and functions, they should be insulated from the social pressures. For example, are judges getting influenced by the television debates, by the newspaper columns and editorials? And this is where we will also come across doctrine of collective conscience, where in some cases the Supreme Court has said We don't have to satisfy basically the collective conscience of law, but we have to satisfy the collective conscience of the society. So judges, when they perform their task, their functions, they should be insulated from the social pressures. They should be insulated from their own inherent bias. For example, I am a judge, but at the same time, I am homophobic, for example. But whenever a case comes to me involving LGBTQIA plus community, should I decide this case based on my inherent bias against this community? Or should I look at this case and adjudicate this matter keeping the fairness in mind, principles of natural justice in mind, Article 14 in mind, Article 21 in mind? That's what we call independence of judiciary. And if this question comes in your exams, what do we mean by independence of judiciary? This is how, and this is what you can write. An independent judiciary means the insulation of the institution from the executive and the legislative branches of the state. But according to Chief Justice of India, Justice Chandrachud, it also means the independence of individual judges in the performance of their roles as judges. And the art of judging must be free of social and political pressure and from the inherent biases which human beings hold, because we hold certain biases within, but that should not get reflected in your judgments, in your pronouncements. The independence of judiciary depends on the freedom of each and every individual judge to function in office without the pulls of the political pressure, social compulsions and inherent bias. When we look at Supreme Court, independent India's first Chief Justice, Justice Kania, he extolled his judges, pleaded before the judges that you should hold true to three principles. And these three principles will form the foundation of the institution of the Supreme Court. And which are these three principles? First is independence of judiciary and the kind of independence that we discussed previously. Second, Constitution should be interpreted not as a rigid document which can't be changed, but should be interpreted as a living organism. And third, the need to secure and retain the respect of the citizens for the Supreme Court as a legitimate institution. And that is perhaps why the Supreme Court, high courts have the power to punish people for contempt. If you are scandalizing the court, if you tend to scandalize the court, because if you attribute motives to the judges, scandalize the court, ultimately people will doubt this institution called judiciary. To prevent that from happening, that is why courts have the power to punish people for contempt. And Justice Kania said, these are the three virtues, these are the three principles that you have to hold together. And that will lay the foundation of the institution of the Supreme Court. But at the same time, how do we look at this independence of judiciary when it comes to judicial appointments? Because judicial appointments have been in the news. You would realize that because of the second judge's case, and I don't have to elaborate because I'm assuming you would know that, obviously you have cleared the prelims, the third judge's case, as well as what we call the fourth judge's case, which is the NJAC judgment. The Supreme Court has arrogated the power of judicial appointments onto itself. And that is how, after the second judge's case, the Collegium system of judicial appointments came into the picture, making India perhaps the only country where judges are appointed by themselves. And when NJAC judgment was given by the court, delivered by the court in 2015, Supreme Court said two things. Supreme Court said, number one, independence of judiciary is part of the basic structure of the Constitution, as well as primacy of judiciary in judicial appointments is also part of the basic structure of the Constitution. Now, what do we mean by that? In second judge's case, you would know Supreme Court said the word consultation, as it occurs in Article 124, does not mean consultation, it means concurrence. But the second judge's case did not only talk about the literal meaning or changing the meaning of consultation to concurrence. It also said that primacy of judiciary in judicial appointments is part of the basic structure of the Constitution. What do we mean by that? Because in today's system, Collegium system, the Chief Justice of India enjoys a virtual veto. Any name which is not acceptable to Chief Justice of India, even if this name is acceptable to 4 other judges of the Collegium, this name cannot be sent to President for appointment. Because Chief Justice of India enjoys virtual veto when it comes to judicial appointments. And then when NJAC was enacted in the year 2014, what this NJAC did? It created an institution to replace Collegium system, having Chief Justice of India, 2 senior judges of the Supreme Court, Law Minister of India, and 2 eminent persons. And these 2 eminent persons would be selected by a committee comprising up of the Prime Minister, the Chief Justice of India, and leader of the opposition in Lok Sabha, or leader of the single largest party in Lok Sabha. And the Supreme Court said, if 2 people in this NJAC do not agree with a name, this name cannot be sent to President for appointment. Which means these 2 eminent persons and the Law Minister, they will veto, they will block any name which is recommended by the Chief Justice and 2 senior judges of the Supreme Court. This would basically mean that the primacy that judiciary enjoys in judicial appointments, which is part of the basic structure of the Constitution, would get violated. So Supreme Court said independence of judiciary would also have to be then interpreted as primacy of judiciary in judicial appointments, and this is also part of the basic structure of the Constitution. You may be asked about critically examine the Collegium system of judicial appointments. And if that's the question that would be asked, let's see how you should approach this particular question. Second judge's case, as I said, was not simply the linguistic move of reading consultation as concurrence, but the finding that judicial primacy in appointments was an indispensable feature of judicial independence, which in turn is part of the basic structure of the Constitution. Although, to tell you something technical here, there is a view that the second judge's case did not rule that primacy of judiciary is part of the basic structure of the Constitution. That was not said by the Supreme Court in the second judge's case. But in the fourth judge's case, one of the judgment was authored by Justice Kehar. And Justice Kehar assumed, as the critics would say, that since second judges spoke of judicial appointment as part of the basic structure, that is why now we will also say that judicial primacy is also part of the basic structure of the Constitution. Let's now look at the arguments in favor of the Collegium system, because we have to look at the arguments in favor of the Collegium system as well. Justice J.S. Verma, who authored the judgment in 1998 in the third judge's case, when there was a presidential reference under Article 143. Justice J.S. Verma thought that today there are lots of vacancies in judiciary, in Supreme Court, in high courts, and the executive is not proactive enough in filling these vacancies. Now, through this Collegium system, we will be able to initiate the process of appointment, and we will be able to recommend names to the president, and that's how these judges would be appointed. So there will be a quick way, a seamless way of appointing judges to the judiciary. But even then, this second judge's case did not efface the constitutional scheme. Because even with the Collegium system, executive still has a role. The name is recommended by the Collegium system, it goes to the president. President even now has the power to ask for reconsideration of that name. The judicial primacy exists only when there is a stalemate. Only when the Collegium insists on a name, but the government is not willing to appoint that person, the Collegium system can sit down and say, no, you have to appoint our recommendation. Because according to second and third judges' case, the recommendation of the Collegium system is binding on the government. So one argument in favor of the Collegium system is that contrary to the popular perception that judiciary has arrogated this power to itself, that's not the case, because executive continues to perform a very significant role in appointment. It's only when there is a stalemate that the view of the Collegium holds primacy. Although we have seen instances where the names recommended by the Collegium, they are either not accepted by the president, by the executive, or whether they are accepting or not accepting, these names have not been approved. In a sense, these judges have not been appointed. Gopal Subramaniam was one case, and there have been various other instances where the recommendation of the Collegium has not been accepted by the president, by the executive, which means what is there? There is much ado about nothing. Second, even before the Collegium system, there was a near uniform practice that whatever is recommended by the Chief Justice would be accepted by the President, by the Executive, and those names will be appointed. Because even before the Collegium system, there used to be consultation with the Chief Justice of India. And the Chief Justice of India's recommendation was given primacy. Yes, there have been instances, for example, when after Justice Sikri's retirement, Justice A.N. Ray was superseded. He superseded 3 other judges to be appointed as the Chief Justice of India. Then Justice Khanna was overlooked and Justice Beg was appointed as the Chief Justice of India because Justice Khanna gave a critical judgment, in a dissenting judgment in ADM Jabalpur versus Shivakant Shukla, which is also known as the habeas corpus case in 1976. But there have been exceptions, but broadly, there has been a near uniform practice since the framing of the Constitution of the President accepting the advice of the Chief Justice before finalizing an opinion, before finalizing an appointment. So what is this fuss all about? Third, principle of separation of powers precluded the executive from having the final say in appointments. That's the separation of powers. Executive cannot have the final say because that would disturb the separation of powers. These are the arguments in favor of the Collegium system. The primacy of judges in judicial appointments. And what is this primacy? The initial and the final voice. Because the Collegium system will initiate the process of filling these vacancies. And they will have the final say. Whatever their recommendation is, that is binding on the President. This aspect of primacy of judges in judicial appointments is necessarily entailed in the concept of judicial independence. And since it is part of the judicial independence, it becomes part of the basic structure of the Constitution. So Collegium system does what? It accepts, favors, puts a stamp of authority on the independence of the judiciary. But what are the arguments against Collegium system? But first, let's look at the arguments in favor. 2 more points which I missed. As I said, Justice Verma, he hoped the Collegium system would lead to a reduction in the judicial vacancies because now Collegium will initiate the process and fill these vacancies. But you might also wonder, what about NJAC? The presence of Union Law Minister and the presence of 2 eminent persons. Critics would say that NJAC was the beautiful solution to Collegium, because NJAC consisted of Chief Justice of India, 2 senior judges of the Supreme Court, that means representatives of the judiciary, Law Minister as the representative of the executive, and 2 eminent persons, which means they are part of the civil society. So in this NJAC, judiciary, executive, civil society gets representation. This is a beautiful system to replace Collegium system. But we need to understand that it is difficult to hold this wisdom that appointment of judges can be shared with the political executive, because that would go against the independence of judiciary. Because we said independence of judiciary means you have to insulate judiciary from executive and legislative branches of the government. And even if you're talking about 2 eminent persons, in India, the development of civil society, it has not evolved. So the expectation from the judiciary, which is to respect and safeguard the rights of the citizens, can only be ensured by keeping it absolutely insulated and independent from the other organs of the state. These are the arguments in favor of the Collegium system. Then let's look at the arguments against. Dr. Ambedkar said the most important office under the Constitution of India is that of the CAG, and then that of a judge. During the Constituent Assembly debates, Mr. Aladi Krishnaswamy Iyer, he had warned that if you give unrestricted power to the judiciary, it will transform itself into a super legislature. And perhaps that is what is happening. Super legislature in the sense, we are talking about judicial legislation. Judicial legislation, if you look at this term, it's basically an oxymoron. Judiciary is legislating, which is not the job of the judiciary, which is the job of the legislature. We are talking about unrestricted powers to the Supreme Court under Article 142, where Supreme Court can give any order so as to give complete justice. Judiciary has the power to strike down a constitutional amendment. Judiciary has evolved itself into an institution which can decide what is basic structure. And this is what some people call is the tyranny of unelected, because the judges are unelected, over the elected representatives in the parliament. And that's perhaps what the court has done because of the second judge's case. And what they have done, they have effectively rewritten the constitution and have come up with a collegium system which finds no mention anywhere in the constitution. So judiciary, which has the job of defending the constitution, has now innovated a structure which does not exist, which did not exist in the original constitution. 99th Amendment, which enacted NJAC, it tried to rebalance to some extent, but ultimately failed because in the fourth judge's case, Supreme Court said NJAC is unconstitutional. There was only one dissenting judge, Justice Chalameshwar. But something else. Did NJAC violate independence of judiciary? The Constituent Assembly, it recognized the need that judiciary should be independent. But it did not seem it fit that we should give the power of appointment also to the judges, power of removal to the judges as well. So appointment will be done by the executive, removal will be done by the executive based on the resolution passed by the legislature. Why was this structure created in the first place? Because this is what we call doctrine of checks and balances. So appointment with the executive, removal with the executive based on the resolution passed by the legislature, this was meant to ensure vital separation of powers, checks and balances. But Constituent Assembly still thought that we should give independence to judges. How? Number one, judges do not hold office during the pleasure of the president. Governor does, Prime Minister does, ministers do, but not the judges. They remain in office till a retirement age, which is 65 for the judge of the Supreme Court, 62 for the judge of the High Court. Did NJAC snatch this independence? No. Second aspect of independence of judiciary. The Constituent Assembly said the salaries of the judges of the Supreme Court shall be charged on the Consolidated Fund of India. The salary of the judges of the High Court charged on the Consolidated Fund of the state. The pension of the High Court judges charged on the Consolidated Fund of India, which means it is not subject to the vote of the Parliament. Did NJAC snatch this very important facet of judicial independence? No. Third, the judges can be removed by the president through a very complicated process of removal. And such is the complicated process of removal that till date no judge of the High Court or the Supreme Court has been removed. Did NJAC snatch this independent feature of the judiciary? No. Fourth, power of the judiciary to punish for its contempt. This is how Constituent Assembly thought we will give independence to this institution. Did NJAC snatch this feature? No. Conduct of judges. There is a limitation. The conduct of judges cannot be discussed in the parliament, in the legislature, unless and until you are bringing a motion to remove the judge. That's how the judges were insulated from the legislature. Did NJAC snatch these powers which were meant to accord independence to this institution called judiciary? No, it did not. So how did NJAC violate independence of judiciary? Another argument. When drafting the Constitution, the Constituent Assembly took great efforts to ensure that judiciary was independent of any coercive political influence. To that end, it introduced a number of significant provisions in the Constitution, such as these. But as valued as judicial independence was to the Assembly, to the Constituent Assembly, it did not see that we will vest the power of appointing the judges to the executive as a violation of this principle. But it is for checks and balances, which is a vital cog in the checks and balances to ensure separation of powers. A broad process of consultation with several important authorities was mandated to further validate the system, but ultimate authority was placed on the president. Constitution said the judges of the Supreme Court and High Court shall be appointed by the president, after consultation with the Chief Justice of India, after consultation with such other judges of the Supreme Court and High Court as the president may deem it necessary. Such other judges, this phrase is important, such other judges. And these such other judges can also be junior judges, who the president would think worthy enough of consulting. But the Collegium does not talk about these junior judges. It talks about Chief Justice and senior judges of the Supreme Court. So it's a classic case of judiciary arrogating the power to itself, which was not given to it by the Constitution, by the Constituent Assembly. Such a system. And what is the system? Very important point. Why should a judge be appointed by the executive and removed by the executive based on the resolution passed by the legislature? Why? Because what's the job of the judiciary? To impart justice. What is the role of the judiciary? To strike down law passed by the parliament as well. If appointment is done by executive, removal by the executive after the resolution passed by the legislature, this entire process, what it will do, it will give democratic legitimacy to the court. But now this democratic legitimacy is gone. In a sense that judiciary has become so powerful that it can appoint its own members. Through the second, and this is something that you can write in your answers, through the second and the third judge's case, the Supreme Court virtually appropriated onto itself the power to appoint judges. As the nature of appointments made in the last 2 decades have showed, the decisions exemplified a concern expressed by former US President James Madison, wherein he says, the accumulation of all powers, whether it is legislative, executive, judiciary, in the same body, in the same individual, may justly be pronounced as the very definition of tyranny. And that's what former Law Minister, Finance Minister, Mr. Jaitley would say, tyranny of unelected over the elected. This court becomes very important. Then look at the practice in UK. There is a Judicial Appointments Commission there as well, and which is completely insulated from executive. But even there, the Lord Chancellor retains the power to reject the nomination made by this commission. Given that originally enacted constitution, that is a beautiful point. How is NJAC unconstitutional? If you are saying NJAC is unconstitutional, then you should well say that the original constitution was unconstitutional. Because original constitution only gave judiciary a consultative role. Consult Chief Justice of India, consult other judges. But NJAC did not give you a consultative role, it gave you a determinative role. Where Chief Justice and 2 senior judges, they may veto any recommendation coming from eminent persons and the law minister. So it is unimaginable, unfathomable how the NJAC, which accorded judiciary not merely a consultative role but a determinative one, was found to infringe the independence of judiciary. NJAC only tried to do what? Recalibrate the system to ensure that there is checks and balance, to ensure separation of powers is maintained. And this separation of power is also part of the basic structure of the Constitution. That is theme number 2. We discussed independence of judiciary as one theme and then linked it to the appointment of judges, where we critically analyze the Collegium system. Now let's look at the pendency of the cases. Why are there crores and crores of cases pending? For that, lots and lots of articles have been written, but not acted upon. Pendency of the cases is also because loopholes in law. The law has been passed, but there are enough loopholes in the law which can be manipulated, and ultimately matter goes to the court for adjudication, for the interpretation as well. And this also speaks volumes about Parliament as an institution, because for the past decade at least, the quality of debates in the Parliament has been reducing. The bills have been passed without debate. On an average, a bill has been passed in less than 7 minutes. More than 50% of the bills have not reached the select committee route, which primarily means that the quality of laws passed by the legislature has been on a decline. When Jammu and Kashmir Reorganization Act was passed in 2019, after that, if you were following the news, hundreds and hundreds of changes were made to that law because there were grammatical mistakes as well. There were issues with the law. So one reason why we have lots of pendency of the cases is because the number of cases reaching the court. And that is primarily because the law has enough loopholes for which we have to go to the judiciary, because judiciary is the final interpreter of the Constitution and the laws. Second, frequent amendments or frequent adjournments. The lawyer seeking frequent adjournments, and on an average there are 12 adjournments in a single case, and sometimes a litigant has to wait 20 years for his case to get over. And it's a stretch of imagination. How can we call a judgment which was given 20 years later as justice? As the adage goes, justice delayed is justice denied. Pendency of cases because of the acute shortage of judges. Pendency of the cases also because we have not been using technology as effective as we should have been using, so that the petitioners need not come physically before the court. We could have had a large number of virtual hearings. These are the prominent factors which result in the pendency of the cases. Also, unexplored or less explored alternate dispute resolution mechanisms. You and me have a dispute, you tell me I will see you in court. That's gone ingrained into our minds because there are no alternatives that come our way. Although there are, but these are not popular. These have not been marketed properly, for the lack of a better word. And this pendency of cases has also morphed into a social problem. How? In 2019, we saw 4 people who were accused of raping a medical student. They were killed, allegedly in fake encounter. But the common perception was this is good. This should have happened. Why? Because if these would have been arrested, then law would have taken its own course and ultimately the justice would have delayed. So it's better, give instant justice, quick justice, kill them in the fake encounter. Some of the Bahubalis of UP have been killed or have died allegedly in fake encounters, and public perception seems to be in favor of these extrajudicial killings. Why? Because people seem to have lost faith in the judiciary as an institution which is capable of delivering quick justice. Speedy justice, right to a speedy trial, is also a fundamental right under Article 21 of the Constitution, an inferred right. So now this pendency of the cases has morphed into a social problem. How do we look at this? Indian judiciary, which is renowned for its independence and integrity, faces a significant challenge: the pendency of cases. As of 2024, right data, which should be updated data, the current data, as of 2024, there are over 40 million cases pending across various courts in India, causing delays in justice delivery. Less than 1 lakh case pending in the Supreme Court, but most of the cases are pending at the district court level. Addressing this backlog is crucial to uphold the rule of law and ensure timely justice. Various committees have suggested reforms, and adopting best practices from other countries can also help resolve this issue. So the question can be asked in your exam: solving the pendency of the cases, keeping in mind best practices, global best practices, and the suggestion of various committees. Answer. So you have to write in your answer the suggestions of various committees and how can we adopt some of the best practices of the world. This is where you can use a quote as well. French thinker and writer André Gide. Because so many committees have been set up on pendency of the cases. All of them are more or less saying the same thing, but we don't implement it. That's why this quote. Everything has been said already, but as no one listens, we must always begin again. What are these suggestions? Committee recommendations. Malamath Committee 2003. What did this committee say? Let's focus on reforming the criminal justice system, because it was tasked to suggest reforms in the CRPC. It recommended that we should increase the number of judges, use technology for case management, set up fast-track courts so that some specific types of cases such as involving women and children can be fast-tracked and quick justice can be given. Just like we have fast-track courts for MPs and MLAs. Fast-track courts under the POCSO as well. That's the recommendation of the Malamath Committee. And this will reduce the pendency of the cases. Second, Law Commission of India. 245th report, it suggested a simple thing. Let's establish more courts, hire more judges, improve the infrastructure of the existing courts. Said, sir, what sort of a suggestion? This is as obvious as it can get, but we are not able to do it. It also emphasized the need for alternate dispute resolution mechanisms. Arbitration, for example. Yours and my dispute. First, we should explore other alternatives to dispute resolution. Mediation, arbitration, conciliation. And if everything fails, then we can approach the court. National Court Management System. This committee recommended use of technology for better case management so that we have full visibility. It suggested implementing a national grid of court data, digitizing records, because today also we think that we see that the case judgment comes, then it has to be typed. Then if you want to file an appeal, you need that typed document. We still use typewriters to make these case files. Why don't we digitize records? Use video conferencing for hearings to reduce delays caused by logistical issues. And it seems that this is not something too difficult of a task, because during COVID-19, we saw the courts were functioning virtually. Why can't we make it a norm? At least in civil cases, some other cases. Areas Committee, chaired by Justice Malimat, this committee recommended measures such as appointment of retired judges to clear backlogs. There was one report in Times of India, and that report quoted the judges of the Andhra Pradesh High Court. Two judges, they said, if we will work continuously 24 hours, 365 days, it will still take more than 300 years to finish the backlog. Then what is the alternative? Appointment of retired judges to clear backlogs, simplifying procedural laws. Because one thing I told you, the reason is because we have loopholes in law. That is why we go to the courts. Ensuring strict adherence to timelines, because we need to also ensure that the justice is given in a specified time. That's how we can implement the fundamental right, which is right to speedy trial. What are the best practices that we can adopt from other countries? For example, United States. United States uses something called PACER, Public Access to Court Electronic Records. What is this system? This allows parties to access case information online. So what? Then it reduces the need for physical presence. You don't have to be physically present to get these files. And what it does, it speeds up the legal process. I don't want to elaborate on this, otherwise I can give you multiple examples, but we want to finish as many topics as possible quickly, so that, because the mains is upcoming. In UK, they have a well-established, very good system of ADR, alternate dispute resolution. And in many civil cases, mediation is necessary as the first step. Only when the mediation fails, then you go to the court. And since mediation is compulsory, most of the disputes in civil cases get resolved at the mediation level, which means the burden on the court has reduced. And they also use technology. Technology very extensively, because if there are some small claims or minor claims, minor criminal cases, online courts play a very important role. Just like we have Lok Adalats for civil cases, where they dispose of hundreds of cases in a day, thousands of cases sometimes in a day. Singapore, which is known for its efficiency. The country uses multi-door courthouse approach. And what is that approach? It offers not just one, but multiple ADR options, along with the traditional litigation that you can approach the court, but these are the alternatives: mediation, conciliation, arbitration. And they resort to e-filing and virtual hearings, e-filing of the cases. Just like we have now resorted to e-filing of FIR under the Bharatiya Nyaya Sanhita. Australia, they have Civil Dispute Resolution Act. What they say? They encourage parties to resolve disputes outside the court before you can commence litigation. Just like United Kingdom. Which means less and less number of cases will reach the court. Or they set up tribunal system for minor disputes. Now, it's another matter that tribunals have their own issues, but this is something that you can write in the answer. And these tribunals will resolve disputes more quickly and efficiently than the traditional courts. These are the things that we need to write in the answers. If the question is asking you to suggest reforms in which we can resolve the pendency of the cases, keeping in mind the global best practices, Singapore, UK, Australia, United States, these are the examples. But let's look at the conclusion. Resolving the pendency of cases in the Indian judiciary requires a multifaceted approach. Implementing recommendations from various committees, such as increasing the number of judges, improving infrastructure, using technology for case management is essential. Additionally, adopting best practices from countries like US, UK, Singapore, and Australia can provide valuable insights. For instance, integrating robust ADR mechanisms, enhancing case management systems, and leveraging technology can help streamline the judicial process and reduce the backlog. This is a perfect or near perfect conclusion that you can write in your answer and will fetch you an additional mark. But ultimately, addressing the pendency of cases will require concerted efforts of the judiciary, government, and civil society. Because ensuring timely justice is not only a matter of legal necessity, but also a cornerstone of a fair and equitable society. Something important, and as I told you, pendency of cases have now morphed into a social issue. Because if the cases keep on pending and the judgment is given after 20 years, it resorts people to support extrajudicial killings, which is a social issue. People's faith in judiciary takes a hit, which again is a social issue. That is why, to salvage the reputation of the court, we need to take pendency of the cases seriously. And for that, this is something that you can incorporate in your answers. If the question is asking you about a right to speedy trial, because if the justice is delayed, it primarily means justice is denied. Indian preamble, the Constitution's preamble, it talks about justice, social, economic, political. Delay of justice is not simply that you are postponing justice, if not today, tomorrow. But in the long term, it has consequences. This delayed justice slowly, steadily kills justice. The evolution of right to speedy justice, whether it's jurisprudence, whether it's growth, and it has grown as a fundamental human right. Where does it originate from? From the mother of all constitutions, the British Constitution, the famous Magna Carta of 1215. Section 40 of this Magna Carta tells, to no one will we sell, to no one will we deny or delay the right to justice. And it is these delayed right to justice, these last four words, which hold huge political importance for the evolution of human rights. Historically, the Sixth Amendment to the Constitution of US, the oldest federal constitution of the world, it also provides what? In all criminal prosecutions, the accused shall enjoy the right to speedy and public hearing. Whether it is Magna Carta, whether it is the US Constitution, whether it is the Universal Declaration of Human Rights of 1948, whether it is the Charter of Fundamental Rights which is there in the Canadian Constitution, all of them place very important emphasis on the right to hearing within a reasonable time. Don't you know? Comparison of the World Constitution is also part of your GS2 syllabus. Compare and contrast. The right to justice within the stipulated time is being accepted as a universal human right, and so occupies the center stage of national and judicial goals of all the civilized democracies. Let's look at something else. If we have to reduce the pendency of the cases, we need to keep in mind the government litigation. We have to somehow reduce government litigation because the government is the biggest litigant, files the highest number of cases almost, and against whom the highest number of cases have been filed. The government is the biggest litigant. Does the government accept that we are the biggest litigant? Does the Vidhi Center accept that the government is the biggest litigant? And how does the government plan? What is their action plan to reduce government spending, government litigation? Let's take a look. India has about 21 judges for every million people. Who said this? A recent answer given by the government in a starred question. This answer was given by the government in Rajya Sabha. India has about 21 judges for every million people. China, on the other hand, has about 159 judges for every million people. Almost all the committee recommendations, they have said we should move towards 50 judges per million population. Pendency or cases pending in the courts have been the source of agony for government, has been the source of concern for the government. Because cases keep on pending, it weakens the law and order as well. 2017, the Department of Justice of the Government of India, it released an action plan to reduce government litigation. Why? Because the government realized a reality. 46% of the total pending cases in the court system pertains to the government. Hence, government is cognizant of its role in contributing to litigation. But please listen to me carefully. You and me have a dispute. We'll go to the court. And if possible, this dispute can reach all the way to the Supreme Court. We can have a review petition. We can have a curative petition. But after that, finality of justice. But even after that, the government has another option. It can take the route of Article 143, presidential reference, which is not available to you and me. And this government litigation, my dear, places state against an individual. And it's an unequal contest. That's how in 2015 they started LIMS. Very rightly worded, aptly worded concept, LIMS. Legal Information Management Briefing System. So all the different departments of the government, close to 55 ministries, so that they can track what are the kinds of cases that are pending in the courts and effectively manage time for that. And it is this LIMS system which shows, as of 2024 January, 620,000 cases involving the government are pending before the court system. 2018, Law Commission of India, in its 230th report, it said government is the biggest litigant in the system. The status note was released by the government in the National Litigation Policy. It came to the same conclusion that we are the biggest litigant. Various other reports also said the government is the biggest litigant. So what do we need to do? Vidhi Center for Legal Policy, in its report Government Litigation, published in 2018, it gives us insights into where the government can and cannot control the litigation it is party to. For example, 2010 National Litigation Policy, the government said ideally what we should do, the service matters should not be appealed. Service matters which go through the tribunal route to CAT, unless and until there is grave miscarriage of justice, it should not be appealed. And sometimes what happens when the decision goes against the government, they appeal. So government should listen to its own status note, should implement this reform suggested by its own policymakers. Because this policy note given by Vidhi Center, or for that matter National Litigation Policy, it says only those cases involving interpretation of the Constitution, involving constitutional questions should reach the court, should reach the Supreme Court, not others. Clearly not the service matters. That's what the government has to do. There are many good reasons to reduce litigation that involves the government. After that, it involves cost. The costs involved in litigation, it eats into public funds. And as I told you, this court battle between the individual and the state is also a battle of unequals. That's why one aspect that you will have to write, you can even write in the pendency of the cases, that the government as the biggest litigant, it should follow its national litigation policy, its status note, or take heed of the suggestions given by the Vidhi Center for Law and Legal Policy, that service matters should not be appealed. And it is these service matters which consume a lot of court time. Then let's look at a question. Critically analyze the setting up of regional benches of the Supreme Court in India and write it in 250 words. There is Supreme Court in Delhi, because Article 130 of the Constitution says, the seat of the Supreme Court shall be Delhi, or such other place or places as the Chief Justice of India, with the prior approval of the President, determine. So the Supreme Court can sit up in multiple places as well. And this is where the idea of regional benches of the Supreme Court came into the picture. Why can't we have regional benches in the northern, southern, eastern, western India, apart from the Supreme Court that we have in Delhi? What are the arguments in favor? What are the arguments against? What is the conclusion? Let's take a look. Arguments in favor. It will be accessible and convenient. Today, if I'm from Tamil Nadu, I lost a case in the High Court. High Court issues a certificate that you can move to the Supreme Court. I will calculate the costs. I need to have an advocate on record in Supreme Court, a senior advocate. Then I need my lawyer who assisted me in the High Court to also travel for some inputs, boarding, lodging, food, all these costs. Then what do? I give up. Just because the Supreme Court is in Delhi, you give up. Is it justice? One report, which I will tell you what that report is. A survey was conducted that majority of the cases in the Supreme Court in Delhi, they are from the neighboring high courts, which means the geographical proximity helps you to reach the Supreme Court. What about the people in Northeast, in South, deep Southern India? That's why it will be accessible, it will be convenient. And who recommended this? National Commission to review the working of the Constitution, headed by Justice Venkatacharya. In fact, Justice K.G. Balakrishnan, he also recommended setting up regional benches. Because then it will be accessible, it will be convenient. It will reduce travel time, cost for litigants. Second, reduction of backlog. More cases will reach these regional benches, or the cases already pending will be heard by these regional benches. That means the pendency of the cases will reduce. 229th report, Law Commission favored the creation of 4 regional benches to address the increasing backlog of cases so that we can expedite the judicial process. Third, speedier justice. More judges, more benches, quicker the justice, speedier the justice. And this was emphasized by the Malamat Committee on Criminal Justice System, which advocated that you should take measures to reduce delays in the judicial system. Localized understanding. These regional benches, they come in a particular local context. They understand the local nitty-gritties. They understand the local language. They understand the political context, the social context of that place. And their judgments will then be relevant, more informed and contextually relevant judgments. 14th Finance Commission, it highlighted the importance of local context in judicial decision making. And this can be better addressed by regional benches. Decentralization of power. Establishing more regional benches, what it will do? It will decentralize the judicial power which is concentrated in Delhi. What it will further lead to balanced distribution of judicial authority. What it will further do? Reinforce federal structure of India, which Sarkaria Commission on Center-State Relations envisaged. So these are the arguments in favor of setting up more regional benches. And I told you, I'll tell you about that survey. 2011 study was conducted by legal scholar Nick Robinson. He showed that the majority of the cases pending before the Supreme Court are from high courts close to Delhi. The establishment of regional benches may reduce such a geographical bias and make it easier for Indians to access justice. But then there are arguments against. Supreme Court does not accept regional benches, saying it will affect our credibility as a national institution. Further, if these more regional benches are set up, they will come under the influence of the local politics. It will dilute the authority. The Supreme Court's authority as the highest court of land might get diluted with the establishment of regional benches. This concern was also once flagged by the Law Commission. Because if your national character gets diluted, it will then lead to what? Maybe inconsistent judicial verdicts, different regional benches giving different verdicts. Logistical challenges. You have to set up regional benches, which means you need significant resources because you have to set up the infrastructure, the manpower, the finances. The National Court Management Systems, it highlighted the logistical and financial challenges of such an endeavor. Coordination and consistency issues, something that I told you, multiple benches. Can you ensure with multiple regional benches consistency in judgments? Perhaps no. Law Commission noted in its 125th report that there is some importance to a centralized Supreme Court because through this we can ensure uniformity. How do we ensure that more judges who we will have to recruit, they will be of quality? The Shetty Commission on Judicial Pay and Conditions of Service, it highlighted the challenges in uniformly maintaining judicial quality across different regions. We have a centralized case management system where at the central level, because the Supreme Court in Delhi, we have the full visibility of how many cases are pending, what is the stage of that particular case. But with regional benches, we have to then decentralize this case management system, which might lead to administrative inefficiency. On top of that, the judicial bureaucracy. Increase bureaucratic layers, which will slow down the decision-making process. It will create administrative hurdles. And Arrears Committee warned against the potential of bureaucratic expansion because if you create more regional benches, it will proliferate the bureaucratic structure as well, and then it will lead to inefficiency. Conclusion. The debate over setting up regional benches of the Supreme Court in India is multifaceted, with strong arguments on both sides. Various committees have provided valuable insights and recommendations that must be considered. While regional benches could improve accessibility, reduce backlog, and ensure speedier justice, they also pose challenges related to consistency, logistical feasibility, and judicial authority. Any decision in this regard must carefully weigh these pros and cons to ensure that the move ultimately strengthens the Indian judicial system and upholds the principles of justice and fairness. You don't have to take notes of this because I told you I will share the notes once the session is over on my Telegram channel. Then judiciary and holidays. This aspect has also come under severe criticism in the recent past, that there is pendency of the cases in India, and it is because the judges go on holidays most of the times, which is a colonial practice, because when the British would govern India, they would go back during the hot summer season in India. If you look at the number of days that the Supreme Court functions, it functions 193 days a year. High courts are open for 210 days. The trial courts for 245 days. What's the global practice? In England, the High Court judges work for just 185 days. District judges, they're expected to work for 215 days. Singapore, which I told you is considered to be the system of efficiency, they grant vacation for 3 weeks in summer and 1 month in winter. United States, for example, with some exceptions, they used to have long court holidays, but then in most of the states, these long court holidays were kept aside because they wanted courts to be open on all weekdays. Is it because the amount of days that judges spend outside the court in terms of vacations, holidays, that's what keeps the pendency of the cases at the higher side? Perhaps no. Because what do judges do in this time? They brainstorm, they write judgments, they have time to think in what direction do we want our country to go in. In 2022, after the summer vacations, on one single day, 44 judgments were given by the court. How is it possible to give same day when the courts reopened after summer vacation? Same day, 44 judgments. It's possible because these judges were working on their judgments during the summer break. And it's not that the Supreme Court is shut during summer break. There is something called vacation benches. Although the court is on vacation, but there are vacation benches which hear the cases of important matters of public importance. NEET case, for example, the NEET fiasco that we witnessed recently because of the NTA, it was heard by the vacation bench. Mr. Kejriwal's bail petition was heard by the vacation bench. So the judges argue that the top court has always maintained that vacations provide time for researching and writing judgments. The logic and the reasoning behind these judgments serve as precedents for similar cases across constitutional district courts. Because the quality of judgment that the courts will give, the better it is. That was theme number 5. Theme number 6, curative petition. Finality of justice is important. But it cannot be at the cost of justice. The Supreme Court has the power to review its own judgment, the revisory jurisdiction of the court. So your case was dismissed by the Supreme Court, then you can file a review petition. And this review petition is filed within 30 days. And this review petition is either accepted or rejected depending upon whether an error has been pointed out in the judgment or new facts have emerged in that case. I'm assuming you would have read review petition, so I don't have to explain it further. So your case has been dismissed. You can file a review petition within the 30 days of the receipt of that order. And the court will either accept or reject this review petition on the basis of the fact whether you have pointed out an error in the judgment, which calls for the review, or a new fact has been discovered in this case, which calls for the review. But this is where the case would end because it will lead to finality of justice. Res judicata, because you can't keep on litigating on the same matters. But then came Hurrah versus Hurrah judgment. Supreme Court said finality of justice is important, but it cannot be at the cost of the justice. So within a reasonable time after your review petition has been dismissed, you can file another review petition that is known as the curative petition. But the grounds of accepting this curative petition are very narrow. You have to convince the judges that I am adversely affected by this judgment. In a sense, I was not party to this case, but because of this judgment, I am adversely affected. So you hear this matter. Or I was party to this case, but I was not heard. Principles of natural justice were violated. Or the judge did not disclose that he was party to this case in some way, so there is an inherent bias that the judge possessed. Very narrow grounds on the basis of which your curative petition is accepted. And this curative petition, once it is heard by the court, 3 senior judges of the Supreme Court will hear this case, this petition, and the same judges who heard this case previously. And then if this bench decides that yes, this case is fit to be heard, then it will go to the same bench which heard this case. That's curative petition. After so many years, the central government filed a curative petition before the Supreme Court that we need enhanced compensation to the victims of the Bhopal gas tragedy in the Union Carbide case. This judgment came in 2023. Supreme Court dismissed this curative petition. And in the recent 2024, in Delhi Metro Rail Corporation, which was against a firm of Mr. Anil Ambani, what the court did, something curious. That is why this becomes important. What is a curative petition? What can be done? There was a dispute between Delhi Metro Rail Corporation and a company of Anil Ambani, which was meant to operate the Delhi Metro, the Airport Express. There were some defects which this Delhi Metro Rail Corporation had to cure, or they had to take efforts to cure that defect, which according to Mr. Anil Ambani's company, they did not cure. Ultimately, they withdrew from operating this Metro Express, Airport Express. And then it went through arbitration. Arbiter gave award in favor of Anil Ambani's company to the tune of 7,500 crores. Matter went to the Delhi High Court on an appeal. Then went to a division bench of the Delhi High Court. Division bench allowed, okay, we can hear this matter again, you can go to the court. So through an SLP route, special leave petition, this case reached the Supreme Court. Supreme Court dismissed and ruled the award in favor of the Anil Ambani's company. Review petition was also dismissed. But when the curative petition was filed, the court said that the arbiter was wrong. And now Delhi Metro Rail Corporation need not pay 7,500 crores to the Anil Ambani company. And this is for the first time that curative petition was used in commercial dispute. Is this good, bad, ugly? What is it? Let's look at what this curative petition is. Some slides are missing. There have been instances where Supreme Court has found certain shortcomings in its own judgments, even after dismissal of the review petition. In such cases, what the aggrieved party can do, it can prefer a writ petition under Article 32, where the Supreme Court used to rectify such shortcomings. But imagine this, and listen to me carefully. Article 32 is used when your fundamental rights are violated by the state. But judiciary does not come under the definition of the state under Article 12. So how can you use Article 32 to file a writ petition against the Supreme Court order? However, in such cases, the writ jurisdiction of the Supreme Court was far from the real to correct such errors, as Supreme Court did not fall in the definition of the state under Article 12, which is required for you to invoke writ jurisdiction. Then there is something called certiorari. Supreme Court can invoke certiorari against a judicial body, a quasi-judicial body. But can one bench of the Supreme Court issue a writ of certiorari against another bench of the Supreme Court? That has not happened. It's impermissible. That is why the year was 2002. The Supreme Court, in the interest of justice, invoking its power under Article 142 of the Constitution, because this is where the Supreme Court can issue any order so as to give complete justice. The Supreme Court in Ashok Kumar Hurra versus Rupa Kumar Hurra used its inherent power under Article 129 and 142 to call for a curative petition. Because finality of justice is important, but it cannot be at the cost of the justice. But what are the grounds? If you can prove that principles of natural justice have been violated, your curative petition can be accepted. How do you prove it? In that you were not a party to this list, to this case, but the judgment adversely affected your interest. Or that you were a party to this case, but you were not served with notice, which means the judgment was given ex parte without hearing the other side. Or when there is an inherent bias, as I told you, where the learned judge has failed to disclose his connection with the subject matter, and then the judgment has adversely affected the petitioner. These are the grounds on the basis of which your curative petition can be considered. Then, as I told you, the process, the curative petition has to be first circulated to the bench of the 3 senior most judges and the judges who pass this judgment. And then when the majority decides that yes, this matter needs to be heard, then the same bench has to hear as far as possible and pass appropriate orders. But then what are the recent instances? Supreme Court in Delhi Metro Rail Corporation for the first time considered the merits of a commercial dispute in curative petition. These are the facts of the case which you don't need to know from the examination perspective, but what you need to know, is it permissible for the Supreme Court to cure a matter that has passed muster at 2 stages before it? First the Supreme Court judgment, then the review petition, 2 times, and then you will use curative petition to cure this matter. In what sort of cases should this power be exercised? And what prevents that you will file another curative petition? And then what happens to this doctrine of finality? Justice has to be final at one stage. Then in 2023, Supreme Court Constitution Bench dismissed Centre's plea for enhanced compensation from Union Carbide Corporation. After this matter, theme number 7, some important judgments. It's 11:20, we have 10 more minutes. Let's see where we will reach. Kaushal Kishore versus State of Uttar Pradesh. A statement, rape happened in Bulandshahr in UP. Mr. Azam Khan was the minister. He said no rape took place, this is a political controversy. Matter went to the court saying should additional curbs be imposed on a minister other than those mentioned under Article 19 Clause 2 on his free speech. The Supreme Court said no, there is no need to add more restrictions under Article 19 Clause 2 for a minister. But even then, the Supreme Court in a landmark judgment said that if a private entity violates freedom of speech and expression, because normally fundamental rights are applicable against the state, the vertical application of the fundamental rights. But the Supreme Court said you can file this case even against private entity. That judgment is the Kaushal Kishore judgment versus State of Uttar Pradesh. Second, euthanasia judgment, where a judgment was given by the court in 2018, where Supreme Court in common cause case said a right to die with dignity is a fundamental right, and also said AMD, Advanced Medical Directive, which is right of living will, is also part of the Article 21 of the Constitution. But then implementing this became very, very difficult, because you had to write this Advanced Medical Directive, your living will, then get it countersigned by the first class judicial magistrate. Then if it is to be used, then medical board is to be set up. Then the doctors who will be part of this medical board need to have 20 years experience, which is very difficult to find in a non-urban area. And that's how the Supreme Court made the process simpler, simplified the procedure to withhold life support, because only passive euthanasia is allowed, where if you are surviving on the life support, you just have to switch off the life support, ventilator support for example, and mercy killing can take place. What are those simplified norms that I have mentioned here? Those are part of my notes as well. I will share it with you after the class on my Telegram channel. Let's look at the last theme. This is very important. Analysis of the doctrine of essentiality. We have Article 25 of the Constitution, which says, subject to public order, morality and health, and subject to other provisions of this part 3 of the Constitution, every person will have the fundamental right of conscience and freedom to freely profess, practice and propagate one's religion. So if your right to practice your religion is a fundamental right, Supreme Court took it upon itself to decide what are essential features of your religion and what are non-essential features of your religion. What are the essential features of your religion will get protection, and non-essential features will not be protected. In the Karnataka hijab ban case, this doctrine of essentiality was invoked. In Shabarimala case, this doctrine of essentiality was invoked. But what is the origin of this doctrine of essentiality? Developed by the Supreme Court to determine which religious practices are essential to a religion, and if they are essential, they merit constitutional protection under Article 25 and 26. And it is this doctrine which has sparked considerable debate amongst civil society, amongst constitutional experts, so on and so forth. This doctrine was first articulated in Shirur Math case, where the Supreme Court held that only those practices that are essential and integral to a religion are protected by the Constitution. In a sense, there is a religion, and there are some practices which are part of this religion. Is this practice essential or not? In a sense, if we remove this practice, will the religion collapse or will the religion survive? If the religion survives, this practice is not essential, which means this practice will not get protection if it violates fundamental rights. That was the whole concept of Shirur Math case, the doctrine of essentiality. And later on in Dargah Committee Ajmer, then in Sheshamal versus State of Tamil Nadu, the court distinguished between essential and non-essential practices. But let's look at arguments in favor of doctrine of essentiality. And then we will look at the arguments against. Very important topic, can be relevant for your upcoming mains exam. Protection of genuine religious practices. India is religious as Europe is secular, said Mr. Harcourt. Religion is a deeply personal thing, and at the same time it pervades our society. How do we prevent the misuse of religion? Because in this religion, some rituals, some practices may creep in, which will violate Article 14, Article 15, Article 19, Article 21, Article 25. This is where the courts come into the picture. And the courts, through this doctrine of essentiality, only protects genuine religious practices. And this confirms with the principles of Aristotle, who said essential and accidental should be separated from each other. Constitutional expert H.M. Sirvai, he emphasized that this doctrine helps in distinguishing between essential and peripheral practices to ensure that only the core principles, core tenets of that religion are preserved. That's argument in favor. Second, it helps in giving a sense that we are a secular state. What constitutes an essential religious practice? The court ensures that the state remains secular and does not support those practices that might harm public order, morality, or health. Granville Austin, he noted that the doctrine aligns with the Constitution's vision of a secular state that upholds individual rights without endorsing a particular religion. That's the argument in favor of essential religious practices. What are the arguments against? As a judge, I may be well versed in the law. I may be well versed in the criminal code, even in the Bharatiya Nyaya Sanhita, the constitution, comparison of the world constitution, so on and so forth. But am I competent to decide purely theological issues? And am I competent in matters related to religion? How can I decide what is essential, what is not essential to a religion? This is exactly what Justice Indu Malhotra said in Sabarimala case, that the judges should not use their personal biases in deciding what constitutes essential and non-essential features. Those who criticize, for example, Falias Nariman, he says the doctrine involves the judiciary in religious matters, but you should not get involved there because that should be the responsibility of the religious institutions, religious authorities. It is this critique which resonates with Immanuel Kant's separation of nominal and phenomenal realms, religious beliefs and governmental state concerns. That should be separated from each other. That's secularism. Through this doctrine, it is inconsistent as well as subjective. For example, in one matter, where a Muslim police officer was dismissed for sporting a beard, the matter reached the court whether beard is an essential religious practice in Islam or not. The court did not go through the religious texts, the Quran or other scriptures to see whether Islam lays emphasis on beard. But the court said, look at the contemporary Muslim personalities, they are not sporting a beard. But should capturing the live cobra during the Nag Panchami festival, is it essential part of the religion? Supreme Court said no. Because this practice originated in 1965 or 1966. And the Anand Margi faith originated in 1955. So when the faith can survive without a practice, this practice is not essential. So in some cases, the court rely on text to see whether it is integral or not integral, essential or not essential. In some cases, it looks at what? The empirical reality. So it is inconsistent and it is subjective. It depends on the judges. Just like this doctrine of rarest of the rare is subjective. That's what Justice Bhagwati asked, P.N. Bhagwati. Am I to live or die depending upon how benches are constituted from time to time? Is it not violative of the fundamental rights enshrined to me under Article 14 of the Constitution? Because if my case goes to one bench, they will say what crime you have committed is not rarest of the rare. And if the same case goes to another bench, they will say this is the rarest of the rare case. So this doctrine, rarest of the rare, has all the elements of a roulette table. Subjective. MP Jain pointed out that what is considered essential in one case might not be seen as such in another. Perhaps Friedrich Nietzsche was right. There is arbitrariness in human interpretation. Impact on religious freedom. Justice Indu Malhotra said, what is essential to a religion should be determined by the religious community themselves. I, as a religious community, will consider this practice as essential, but the court will say no. Thereby what it does, it restricts my freedom of religion, which is a fundamental right under Article 25. Rajiv Dhawan, constitutional expert, lawyer, he says that doctrine often undermines the autonomy of religious communities by subjecting their practices to judicial scrutiny. It is this concern which mirrors J.S. Mill, and he advocated for individual liberty, where the imposition of external standards on religious practices can be seen as a form of paternalism. The state telling you what should do, what you should not. Here the court is doing that. Just like there was a debate that voting should be made compulsory. Pratap Banu Mehta argued that voting is a laudable value. But a vibrant, flourishing democracy requires a variety of dispositions, including an option of disengagement. Voting must remain an act of choice, not compelled by allurement or force. But then what is the way forward? Perhaps a constitutional amendment that clearly should spell out the scope of judicial intervention in religious matters. Although one thing I should tell you, that after the Sabarimala verdict, when a review petition was filed before the Supreme Court, Justice Ranjan Gogoi was the Chief Justice of India. He kept the review petition pending. He neither accepted that review petition nor rejected. Why? Because he said there are other matters which raise similar issues. For example, the same issues as were raised by the petitioners in the Sabarimala case, the same matters are there in other cases. For example, ban on women in entering the dargahs, the female genital mutilation practiced by the Dawoodi Bohra community, where in the Dawoodi Bohras they have a belief that when the girl attains the age of 6 or 8, her clitoris should be either completely or partially cut, because this clitoris is the unwanted skin. It's the source of all sin and should be cut. Should this be allowed? A ban on Parsi women who marry a non-Parsi inside the fire temple. Should this be allowed? So the Supreme Court said, till we decide these three matters, we'll keep the Sabarimala review petition pending. But then the Supreme Court said we should set up a 9-judge bench. And this 9 bench should decide whether and how far we can decide on essential religious practices. But this 9-judge bench, till date, has not been constituted. Another solution can be formation of religious expert panels, which can advise judiciary on matters pertaining to religious practices. This will do what? It will bridge the gap between the legal and theological expertise, because the judges don't have theological expertise. Or the role of the legislature. It can define and regulate religious practices by passing clear, unambiguous laws that should outline what is acceptable, what is not acceptable, so that the judiciary's intervention is minimized. We can also promote interfaith dialogue. Encouraging dialogue between different religious communities can help in forming a common understanding of what constitutes essential practices. This can lead to self-regulation within communities and reduce the need for external intervention. We looked at the arguments in favor, we looked at the arguments against. Let's look at the conclusion. The doctrine of essentiality serves a crucial function in balancing religious freedom with the state's secular objectives. However, its application has raised concerns about judicial overreach, inconsistency, and the impact on religious autonomy. By considering constitutional amendments involving religious experts, enhancing legislative clarity, and promoting interfaith dialogue, India can move towards a more coherent and respectful approach to adjudicating religious matters. This balanced approach can uphold the constitutional values of secularism and religious freedom while ensuring that justice is served fairly and consistently. These were the themes that we had to discuss from Judiciary. The remaining part of the Conquer Mains would continue on the Unacademy app. That's something that I told you right at the start. Should you wish to join that program, the course fee is 999, which you can access on the Unacademy store. Although you may see 1999 as the fee, but you can apply IAS English as a code, and then the course fee becomes 999. Clear? That is it for tonight. All the best for your mains examination. I hope to see you on the Unacademy platform with more and more interesting, quick discussion on important matters that can help you write good, cogent answers in your mains examination. And if this session has been of some help to you, please let me know in the comment section. And the link to join the Telegram channel is available in the video description. You can subscribe to that channel and I will share the notes with you. Thank you so much for staying with me. Have a great night ahead. Revision time. Good night.
NCERT books are unavoidable to crack the IAS exam. Not only is the content of these books authentic, but these books also help a civil services aspirant to build conceptual clarity. And most importantly, lots of questions in the civil services examination are directly asked from NCERT books. But the aspirants often find it difficult to cover these books, or worse, they even end up ignoring these books. We at Unacademy IAS English are going to make the reading and understanding of the NCERT books easier. We present NCERT Fundamentals course, a free initiative of Unacademy IAS English. What are the highlights of this program? Comprehensive coverage of the most relevant NCERT books for the civil services exam. Prelims and mains practice questions in each session to test your understanding of the fundamental concepts. This course begins from 12th of July every day at 6 p.m. right here on our YouTube channel. Subscribe to the channel now.